distinguished professors, dear colleagues, ladies and gentlemen, I'm really honored to be a part of this conference, presenting my modest contribution. And my topic is the child rights in the Council of Europe framework. It is, when we speak about body of law within Council of Europe concerning child rights, it is a really enormous number, vast number, huge number of legally binding but non-legally binding as well legal instruments. So it was a real challenge to make classifications which were necessary to provide some kind of clarity for this work. So I started from the most ratified legal instrument, legal treaty in the history of international law, the UN Conventions on the Children's Rights, even those treaty is not within the Council of Europe framework, of course, but I took it metaphorically speaking, as a sun in the central part of solar system, and all legally binding and non-legally binding instruments of the Council of Europe revolved. I took metaphorically like those instruments revolved around the Council of Europe to get some insight concerning child rights. So I will skip those parts of the, sorry, just to, okay. I will skip this part concerning the composition or the structure of the Council of Europe to get to the point, because I want to respect the allowed time. Okay, something is, never mind. Concerning the first part of my presentation, I tried to make classification, to make division of all those documents, all those legal instruments within the Council of Europe framework regarding the child rights. And first of all, I must say that before the adoption of the CRC, there was a path dedicated primarily to the adults concerning human rights. Child rights were not so visible, or at best they were not in the focus of those treaties. A typical example is the original version of the, okay, thank you. Okay, you can use this. Thank you. Original version of the European Convention on Human Rights, where the child are not mentioned in the original text. We can find the terms, the expressions juvenile, minor, but not child, not the best interest of the child as well. So gradually this situation was improving. Of course, child are entitled, has the entitlement to all those human rights because childs are humans as well. But adults were in the focus until the adoption of the CRC in 1989, and then the Council of Europe needed to make some adjustments concerning the legal instruments within its framework. Some of those conventions were adapted to the child rights from the CRC. A typical example is the Convention on Adoption, for example, the European Convention on Adoption, which was fully revised after the adoption of the CRC. And there were, within the framework of the Council of Europe, there were documents that were adopted, child-oriented, more child-oriented. For example, the conventions on the exercise of children's rights, the convention on contact concerning children, and etc., which were focused more on child rights. So what I'm trying to say, I divided all those conventions, treaties, as formally, legally binding instruments in three categories. First, concerning child rights. First are human rights treaties in general. The second category is conventions dealing with family relations in wider sense, in wider context. And the third category is child-oriented conventions, which came into being, into existence after the adoption of the CRC. Of course, this classification is not ideal, but I thought it was necessary to give us some more systematic insight into this vast body of law within Council of Europe framework. So I will just say shortly, human rights in general concerning human rights treaties that generally concerning child rights are, of course, European Convention on Human Rights, the European Social Charter, for example. Then we must also mention the European Court of Human Rights, particularly with its doctrine of positive obligation. It's established after the Marx against Belgium case in 1979. This doctrine enabled the European Court of Human Rights flexible and dynamic approach, and it was really important for child rights, although we must say that the approach of the court is much more nuanced and balanced, having in mind that the rights and interests of the parents and third parties also must be taken into account, and that is something that is in a way not in the line with the supremacy of the best interest of the child. Then family-related conventions. Family-related conventions concerning rights of family members, parental responsibilities. For example, in my paper, I mentioned three of those conventions. I would say, for example, the conventions on the exercise of the children's rights, the European Conventions on the Exercise of Children's Rights. For example, just a couple of sentences concerning that treaty. The makers, the creators of that treaty wanted to be complementary, to complement the CRC, particularly concerning procedural rights involving the right to express views of the child. But some criticisms, even at least in my opinion, this convention is very important. For example, in Serbia, we did not ratify that convention, but the Family Act incorporated many provisions of that convention without formal ratification. It is important, even, at least in my opinion, even that convention faces many criticism by some family law scholars and legal experts. What do they say? They're saying that they're bothered with the formulation that child should be of sufficient understanding as that Council of Europe Treaty says, or sufficient understanding to exercise the participation rights in the procedure. And on the other hand, the CRC, in CRC we may find provision in an article, famous Article 12, that child should be capable of forming views, not of sufficient understanding, but capable of forming views. And what is the consequence? Consequence of that solution in the within the Council of Europe framework, within the mentioned treaty, is that many national legislation set age limits for exercising participation rights, age limits, fixed age limits. For example, in Serbia it is 10, in Norway 7, it is the lowest. Just making an example, making the examples, and of course, the UN Committee on the Rights of the Child said that in its general comment it is not allowed to interpret that in that way because age limits should not be fixed, and you all know that comment, of course. Then child-oriented conventions. Of course, this was a child-oriented convention. And family-related convention is, I would say, a convention on the legal status of children born out of wedlock, for example, from 1979. This is family-related convention because it concerns mostly parental affiliation, establishing parental responsibility. And it was very important in the time it was adopted because abandonment of discrimination of child based on birth, and also we all know the ancient rule about establishing maternity, that status of mother, the establishing of maternity should be the same regardless of civil or family status of mother. So in the context of Marx against Belgium decision of the European Court of Human Rights, it is noteworthy to say that the court invoked the mentioned convention in order to justify the decision in Marx against the Belgian case, where the mother was forced to adopt her own child in order to establish maternity, which of course was very bizarre and unacceptable. So I will end now. I have 45 seconds left. I will try to cope with that. I just want to say that I think that Council of Europe framework is very important. There were some obstacles because there are so many legal counterparts that diminish the effects of the Council of Europe conventions. The Hague Conference concerning on private international law involving Hague Conventions. Then the distinguished professor after me will talk about the EU law concerning child rights, also diminish the effects of the Council of Europe framework. But I think that particularly having in mind the case law of the European Court of Human Rights, still it is highly important, highly flexible, and regardless some development of the others, international and supranational systems, I think that still we must say the Council of Europe is very important concerning child rights, and that the European Court of Human Rights in particular could give so much in their interpretation and applications. Thank you all for your attentions, and that was all. Thank you very much.